We will call this meeting to order. Could we have a roll call, please?
I guess I'll do that.
He can do it. Don can do it.
We got her covered.
Director Cordell,
Yes, here.
Director Cinnamon, Vice President Cinnamon,
Present.
President Griffin,
Here.
Director Ratora,
Here.
and Director Boyd.
Here.
Thank you. A posting of the agenda declaration.
The agenda was posted Monday, December 13th, 2021.
Okay. I'd like to thank everybody for coming. If you would please rise, and if we could get Ms. Decker, would you lead us in the Pledge of the Allegiance, please? Where are we at? Over here. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Item 4 is conflict of interest declarations. Do we have any conflicts to declare?
None for Boyd.
None for Ratora.
Cordell, no.
None for St. Amand. But that being said, I must inform you that I am employed by the federal government. That being said, my opinions expressed tonight are my opinions alone and do not necessarily reflect the opinions of either my employer or the board of directors of the Indian Wells Valley Water District.
Thank you. And I have no conflicts. Item 5 is public comments and questions. This portion of the meeting is reserved for persons desiring to address the board on any matter not on the agenda and over which the board has jurisdiction. However, no action may be taken by the board of directors on any item not appearing on the agenda. Non-agenda speakers are asked to limit their presentation to 5 minutes. Public questions and comments on items listed on the agenda will be accepted at any time the item is brought forth by consideration by the board. When you are recognized by the chairperson, please state your name and address for the record. Do we have any public comment for any item not listed on the agenda? See none, no phone calls. Okay, then we will move on to item 6, which is the board workshop, and I'll turn that over to you, Mr. Worth.
I think Don's going to take
Okay,
it
Don?
from the get-go.
Well, at this time, the board will take their seats out in the audience, and we'll move to the middle. Okay, we'll start with introductions. On your right, my left, is Doug Everts. Doug is a special counsel for the Water District with the firm of Murphy and Everts. On my right, your left, is Jim Worth. Jim is a district counsel with McMurtry, Hartsock, Worth, and St. Lawrence, right?
It is now.
Okay, and St. Lawrence. And I'm Don Zadiba, General Manager for the Indian Wells Valley Water District. So first of all, I do want to thank you for coming out in this inclement weather and being here. Also, I don't know how many people are watching us, but to those of you that are watching this, thank you for participating as well. So this workshop has been noticed as a special meeting of the Board of Directors of the Indian Wells Valley Water District in order to allow the board to attend in compliance with the Brown Act. The board will not be answering questions this evening or participating in the meeting due to the nature of the presentation being based on the comprehensive adjudication. There will be a second meeting like this one to be scheduled after the mailer that you'll hear about later on is sent out. This meeting will likely be sometime after the first of the year. The date will be announced. It would be more efficient for this meeting in terms of the flow of the meeting if questions were held until the end of the presentation. So we'll ask that you refrain from asking questions until the end. And we anticipate the presentation will take about 30 minutes or so, and then we'll be happy to take any questions you have. And just for the format, we'll take questions from the floor first, and then any questions that are from callers, we'll take those after all the comments are taken or questions are taken from the podium here. So at this time, again, I'll turn it over to Mr. Worth.
Thank you, Don. Yes, good evening, everybody. I'm going to provide a brief overview of the background leading up to the district's filing of the adjudication. I'm going to do everything in a brief overview, so we will provide further details either through your questions and our answers or later on in the presentation. For example, Doug, who is special counsel on the litigation, he'll be providing a lot more detail and be able to answer your questions as it pertains to the adjudication. So with that, I'll go ahead and go. The primary goal of this informational workshop is to try to help educate the public regarding the Water District's filing of the comprehensive adjudications. Should know that one of the district's primary goals in filing the adjudication is to help bring certainty with respect to water rights in the Indian Wells Valley Basin, and that would go now and into the future. There's a number of reasons the comprehensive adjudication was selected by or utilized by the districts. One of those, and we'll talk about this in greater detail as we go on, is the fact that there's only one type of a lawsuit where the Navy or the federal government has waived its immunity and subjected itself to state rights. And when it pertains to water rights, that is a comprehensive adjudication, and that is the only form of a lawsuit where you can get the Navy to participate and get a final and binding adjudication as to what the Navy's water right is. No other lawsuit will allow you to do that. And that's important because the Indian Wells Valley Basin is approximately 382,000 square acres, I believe it is, or miles. 301,000 of those are the federal government, either Navy, Bureau of Land Management, or Fish and Wildlife, or Park and Recs, I believe. So the federal government overlies the majority of the basin. So if we're going to have any type of a final determination, it's imperative that the Navy be involved in the process. And the reason why the comprehensive adjudication impacts so many of the people in the valley is because one of the primary requirements of a comprehensive adjudication is that it involves all persons or entities that may claim water rights in the basin. So as a result of that requirement, the Water District, we're going to be serving approximately 22,000, we call them mailers, on landowners and pumpers within the Indian Wells Valley Basin. That'll be happening starting next week, which is really one of the primary reasons for the timing of this workshop. We believe that with the filing of the adjudication and by bringing all of the pumpers and landowners into the lawsuit, it will finally provide finality as a quantification of water rights, as can only be done through a final judgment, which we can obtain through the comprehensive adjudication. It avoids future or piecemeal litigation. Once we have a final lawsuit as to the comprehensive adjudications, we shouldn't be subjected to similar lawsuits because all the pumpers would have had their opportunity to participate. So this should be, it is a big lawsuit, but it should be the only one of its type, or even anything similar to that. And it should help result in a long-term plan of sustainability, which is necessary for the basin, the citizens, and also required by SGMA, which we'll also discuss a little bit more later. It's important to understand that you can't ignore the comprehensive adjudication if you're a pumper or you assert any type of rights to pump or store groundwater. The comprehensive adjudication is likely to finally determine the water rights of all of the pumpers within the basin. And for this reason, if you are a landowner or a pumper that have some type of a rights, it's important that you participate in the lawsuit, appear as a person so you can claim, assert, and protect any water rights that you may have. Doug will go into further detail later, but it's important. I know you've received a lot of notices recently from the various agencies in here. This is not one you want to just throw away. It could have long-term impacts on your water rights. So please be looking forward to that. So with that said, before you go any further, I know that there's a lot of misunderstanding as to who some of the players are on here. So before we go any further, I just want to provide a brief summary of who the players are within the basin, the major players. So with that, the first one, I'll start with the Indian Wells Valley Water District, which is a county water district. Geographical boundaries of the water district are similar to the city's boundaries, and city citizens and district customers, they share a lot in common. And the primary purpose of the district is to provide water to its customers. We also have the city of Ridgecrest. You know, the city has land and land use and planning authorities within the lands within their boundaries. We also have the county of Kern involved. Similar powers as the city, except the county's boundary is much larger. It almost encompasses the entire Indian Wells Valley Basin, with the exception of a portion that goes into Inyo County. I believe it's near Pearsonville, and then there's a portion that also goes into Searles Valley Mineral. So those are the three. They're called the big three. Those are the big three public agencies over the basin that I would say are most impacted by what's going on with the GSP in the comprehensive adjudication. But there's a total of 7 members in the Groundwater Authority. I've already mentioned the Water District, the City of Ridgecrest, as well as the County of Kern. Inyo County and San Bernardino County are both voting general members of the Groundwater Authority, and that makes up your 5. The reason San Bernardino and Inyo County are involved is because I've just mentioned a portion of the basin shoots out into their counties, and so they're members of the GA as well. I mentioned immunity a little bit, and that means that the federal government can choose to participate if they want to in the SGMA process. And in this instance, the Navy, as well as the Bureau of Land Management, although not required, they sit as ex officio non-voting members on the Groundwater Authority. And so those are the 7 members. It's important to note that while the Groundwater Authority is made up of 7 public agencies, 5 voting members, each one of those voting members are each distinct and separate public agencies. They're each run and governed by their own elected officials. Water District has the Board of Directors, City Council, County Board of Supervisors, et cetera. So we're going to get into SGMA in a bit, but these 5 agencies filed, I think you've heard of this, they formed the Indian Wells Valley Groundwater Authority, which is authorized under SGMA, and the primary purpose for the formation of the GA, we'll call it the Groundwater Authority, was to develop and implement what's called a groundwater sustainability plan, and the goal of that groundwater sustainability plan is to achieve sustainability within the basin within 20 years or by the year 2040. So for those of you that don't have a good understanding of the background, it is important to realize that the Water District did not file this adjudication in a vacuum. We didn't just wake up one day and decide in January that they were going to file a comprehensive adjudication. It's important that you be aware of the other facts and circumstances that come into play and the decisions that are going on. So I'm going to give you a quick chronology leading up to the filing, if I may. And before I go into SGMA, I think it's important that everybody recognizes is that there has been stakeholder cooperation in this basin for many decades, long before SGMA was enacted. A good example would be the Indian Wells Valley Cooperative Groundwater Management Group. It was formed in 1995 out of concern for negative impacts of concentrated localized pumping in the intermediate area by major producers. Original members include the Navy, the Kern County Water Agency, City of Ridgecrest, Inyo Kern CSD, the Water District, Searles Valley, Eastern Kern County Resource Conservation District, and the Indian Wells Valley Airport District. Additional members joined later, including Quist Farms, Kern County, Mojave Pistachio, and Nugent Farms were the last ones to join. This was a voluntary organization, and these entities and persons put time and effort into it, and they had certain objectives in mind. And I'm just going to list a couple of those, and they are to limit and distribute additional and new groundwater pumping within the basin in a manner that will minimize adverse effects. They encouraged water conservation. They explored and encouraged the use of recycled water. They participated in gathering and sharing data on the basin to better understand what was going on. And then they were also exploring additional water management programs. And I think there's a list of them on the slide, but I'm certain you don't want me to read them. So real quick, they did, although the group had no real statutory authority or ability to make somebody do something, it's important to note that they did accomplish a number of things. They did accomplish the relocation of major pumping away from intermediate area, groundwater monitoring and water quality sampling. Well drilling was provided by the Navy, and well logging was provided by Searles Valley. They prepared the AB 303 project, resulting in a GIS database system. They really are still working out the brackish water treatment study. And then they all helped to develop the Brown and Caldwell groundwater flow model. I apologize. What's important to recognize is that the Water District thinks, and the reason this was used, that is if the stakeholders can get together and talk about issues, that we're able to reach resolution on those, hopefully with everybody's input. And that is another primary goal of the Water District, is to try to bring cooperation back and then try to reach resolution on the various issues on water-related matters that are going on. The cooperative group, it terminated in 2018 after the formation of the Groundwater Authority, and it was primarily to be replaced by the Technical Advisory Committee. So I'm going to jump into SGMA here real quick, if I may. And again, to SGMA, it's the Sustainable Groundwater Management Act. It was put in place in 2014 and became effective January 1st, 2015. It really is the state's first attempt at statewide regulation of groundwater, as they'd been regulating surface waters and other types through the State Water Resources Control Board prior. So this is their first attempt at statewide regulation. In a nutshell, SGMA requires medium and high priority basins, we're in a high priority basin, to develop and implement a groundwater sustainability plan that will achieve basin sustainability within 20 years or 2040. As we've talked about, the Groundwater Authority was formed for the purpose of developing and implementing the GSP. GSP was approved in January of 2020. It was submitted to DWR, Department of Water Resources, as required by SGMA, and it's presently under review. There's been no final decision on it as of now. So as we talked, the Indian Wells Valley Basin is classified as a high priority, critically overdrafted basin by the Department of Water Resources. It's designated as basin number 6-54 and bulletin 118. And according to the deadline to submit the GSP was January 31st, 2020, and that was timely accomplished. So the GSP is supposed to come up with a plan that brings sustainability to the basin. There's not a real concrete definition of what it is, but really some people might think of it in terms of, we're going to talk about the safe yield of the basin being 7,650 acre feet. Some people would equate sustainability to meaning you could only pump out the safe yield of the basin so you don't cause any impacts, no water levels go down. Really what the SGMA definition is, you need to manage your pumping in a manner that avoids chronic lowering of groundwater levels, significant and unreasonable degraded water quality, a significant and unreasonable reduction of groundwater storage, and then significant and unreasonable land subsidence that interferes with surface land use. There's a couple of undesirable results related to seawater intrusion, but interconnected surface waters, but they're not really applicable here. So the GSP is attempting to develop a plan that achieves those goals, that is, continued pumping without resulting in any of those undesirable effects. So I'll give you a brief overview of the GSP as it was drafted, some of the primary facts as it relates to what we're talking about. So the GSP estimates that the basin safe yield is 7,650 acre-feet annually. That means that through the various sources of recharge, it's estimated that the Indian Wells Valley Basin receives about 7,650 acre-feet of new water every year. Current pumping is estimated at 22 to 25,000 acre-feet, so you can see that there's a big deficit there, creating a water deficit. Of the 22 to 25,000 acre-feet, approximately 11 to 12,000 acre-feet are pumped by present domestic water pumpers. Those would be de minimis pumpers, those pumpers that are pumping less than 2 years, and their use is estimated at 800 acre-feet. Water District's use is estimated at 6,507 acre-feet. Inyo Kern, CSD 102, Small Mutuals 300, and Toronto Domestic Mutual is estimated at 217. So just those pure domestic pumpers, that's about 8,000 acre-feet per year, right around the safe yield, actually a little bit higher. Navy pumping is currently estimated at 1,450 acre-feet, and there's some indication that that will go higher when, or we don't know that, but that's 1,450. And then if you include Searles Valley Mineral, that's an additional approximately 2,400 acre-feet. So with the domestic pumpers, Navy, and Searles, you've already got water use of about 11 to 12,000 acre-feet in a basin where the safe yield's estimated at 7,650. Most of the pumping over the 11 to 12,000 is done by farmers. So the way the GSP went about it is the Federal Reserve water right can only be determined in the adjudication, as I briefly mentioned. So the GA and the Groundwater Authority and the GSP estimates that the Federal Reserve water right to support the Navy encompasses the entire safe yield. The entire 7,650 acre-feet basically goes to the Navy under the GSP plan. We know that they're only pumping about 1,400 acre-feet right now, so the remaining portion of the Navy water is allocated, if you will. Some don't like that word, but it's allocated to the domestic pumpers to help offset their costs. So the Groundwater Authority and the GSP has come up with a distribution of the water and who gets what, an allocation scheme, if you will. But one issue that comes up is that while the SGMA grants a Groundwater Authority broad power, it does not authorize it to modify or change anybody's water rights. So the GSP can make GSP can be prepared, but it's not a legal determination of anyone's water rights. Here's a couple of quotes from SGMA. A GSA cannot, quote, determine or alter surface water rights or groundwater rights, or to, quote, make a binding determination of the water rights of any person or entity. So the GSP and the water rights, that's still up for challenge because the GSP does not have the final determination on that. So under the GSP, from the water district standpoint, I've already indicated that we pump approximately 6,500 acre feet. Under the GSP plan, the water district was allocated about 4,400 acre feet of this excess Navy water that it's not using. And any water that is provided to a domestic provider that's called excess Navy water, it's not subject to the replenishment fee, which everybody knows is around $2,000 an acre feet. So with the district pumping about 6,500 acre feet, receiving 4,400 acre feet of excess Navy credit, we still have a deficit of 2,100 acre feet. And as a result of that, the replenishment fee is charged to the water district for any pumping over the excess yield or the 2,100 acre feet, which currently it comes out to just over $4 million that the water district is paying. Just for those of you that don't know, the GA is a fee that was imposed on that was authorized by the Groundwater Authority. The purpose of the fee is to help address the overdraft, and it's primarily for the purchase of imported water. The water district is currently paying the fee in full from the money it collects from the water district customers. We are paying it under protest, and that's to protect any rights that we may have, as the water district is not challenging the replenishment fee, but we'll talk about it. It's under attack by two separate lawsuits, one by Mojave Pistachio and the other by Searles Valley. So there's still some uncertainty as to what may happen with that lawsuit. And then finally, with respect to the allocation scheme, neither Mojave Pistachio or Searles Valley Mineral received any excess Navy, so all of their pumping would be subject to the replenishment fee. And I think maybe you've heard a little bit about that. So I've given you an overview of the GSP, and I'm going to give you a quick status of where we are, some of the lawsuits, and then I'm going to go ahead and turn it over to Doug over there. The first lawsuit that was filed regarding water-related matters currently was filed by Mojave Pistachio in November of 2019. Mojave filed a complaint, and it's generally considered a request for a limited physical solution. And we're looking for a physical solution as well through the comprehensive adjudication, but we're bringing everybody in, so ours is going to involve everybody. The Mojave Pistachio lawsuit, it only brings in 4 pumpers: Mojave, Meadowbrook, Searles Valley, and the Water District. It did not include the Navy, so any proceeding or any judgment coming out of that would only be good as to those 4 parties and nobody else. So that was November of 2019. January 20, the GSP was approved and submitted to DWR. After that, both Mojave and Searles Valley, this will be Mojave's second lawsuit, filed separate but similar lawsuits against the GA. These lawsuits were to challenge the Groundwater Authority's groundwater sustainability plan itself and most of the implementing actions that went along with that. One of those would be the replenishment fee. And those were filed September of 2020. They're commonly referred to as reverse validation actions. What that means is Searles and Mojave are attempting to get the court to reverse the actions of the GA in approving the groundwater sustainability plan and the various actions. These cases are all pending. All the cases what we're going to mention, they're all pending in Orange County. You cannot have an adjudication in a county overlying the basin, so it couldn't be in Kern, San Bernardino, Inyo. We ended up in Orange County. The water district, we're what you call an interested person in those two reverse validation actions. We're not actively defending or prosecuting each one. However, there are some allegations in those complaints that assert water rights that are senior to the water districts. So we are involved as parties to that case in case we feel the need to do anything to protect our interests. So there's 3 lawsuits that are going on, all of them by September of 2020. Now, the Water District still has to respond to the Mojave Pistachio lawsuit request for a limited physical solution. And in short, you basically have 2 options from the Water District standpoint. We could have just filed an answer and defended the action filed by Mojave Pistachio against the other 3 pumpers. But that really didn't accomplish many goals, as we've talked about before. That would only pertain to those 4 pumpers, any type of a solution. The Navy would not be involved, nor would any of the other pumpers. So if that case were to be finalized, somebody else, a 5th pumper, could come in and sue under similar grounds and be okay because they're not part of that lawsuit. And you'd start that process over and over again, and who knows when it would end. The other option, and this is the option obviously the district took, was to pretty much not deal with the physical solution, the limited physical solution in that manner, but to file the comprehensive adjudication for some of the reasons that we've discussed previously, and Doug will go over again. One of the big reasons for the adjudication is, again, it allows the Navy to participate. The only way we can get the Navy to participate and have their federal water right quantified. And for those reasons, we've done that, and that's pretty much what I've got right now. So I'll go ahead and turn it over to Doug, and then after that we can answer any questions you might have. Thank you.
Thanks, Jim. Can you hear me now? Is that one? Yeah, okay, here we go. Good evening, everybody. My name is Doug Everts. I want to start where Jim left off, and that's with the Mojave Pistachios lawsuit. And as Jim mentioned, there are 2 lawsuits filed by Mojave Pistachios and Searles Valley against the GA. Those aren't the cases that I'm talking about. The case that I'm focusing on is the Mojave Pistachios case versus Searles Valley, Meadowbrook, and the Water District. And in that particular case, it's seeking what's called a physical solution. That's a fancy word for a settlement or judgment that allocates water. But as you can obviously tell, with 4 parties to a lawsuit, that doesn't serve long-term purposes of certainty and resolving the issues that face this basin. So what the district has elected to do is expand the scope of that to bring all major players into the process to bring a long-term solution into place that benefits this entire valley. Obviously, the major player that was missing initially from the Mojave Pistachios case was the federal government, or is the federal government. And there's a law called the McCarran Amendment. And what that law provides for is it's an act by Congress. And that law says generally that the federal government is immune from litigation in state courts regarding water rights, with an exception. And that exception is that if a comprehensive adjudication is brought, the federal government can be sued in state court. And the theory behind that is that when all the players are involved, there will not be piecemeal litigation. There will be a permanent one-time solution for the entirety of the valley. So I know a lot of people have been asking, say, why are you involving all landowners? Why are you involving all pumpers? The reason is we have to. And that's the requirement of the McCarran Amendment. And the purpose of that, again, is to bring in all pumpers, all landowners, or at least give them notice of the lawsuit to get involved. And that's the reason that we did this, is because obviously the federal government needs to be a player in this process and needs to be at the table, as well as all the producers. Everybody needs to have a say-so in this process. So with that, we have filed the adjudication. It's styled as a cross-complaint, and what that means is that the Mojave Pistachio's original lawsuit was a complaint for a physical solution and water rights determination. The district's lawsuit is a cross-complaint, which is effectively a response in the Mojave Pistachio's case that expands the scope of that process. And again, I want to emphasize that the reason that all landowners and pumpers are being given notice of this is, number one, they should be afforded the right to participate if they choose to do so. But number two, it's a requirement. Seeking a physical solution through the court system, I know going through the courts can be scary, and it's a process most people aren't familiar with. But the process of water rights adjudications and physical solutions and comprehensive adjudications have time and time again proven to be very effective management tools throughout the state of California. Most recently, maybe some of you have heard about the Antelope Valley adjudication. That was resolved through the trial court a few years back, and just this last year or so has been resolved through the appellate courts. In that particular case, it was a much larger geographic area than the basin here, but it involved very similar issues and parties. The federal government was involved in that particular case, both through Edwards Air Force Base and Plant 42. The lawyer from the federal government from the Department of Justice that was involved in that case will be involved in this proceeding. Small pumpers were involved in that particular matter, and I should emphasize there in that particular case, and really all the cases involving physical solutions with respect to small pumpers, is the goal in all of these cases is not to cut off someone's water supply, but to work on a solution that makes sense for everybody. And I can say that in each of the adjudications that I've been involved with and all the adjudications that I'm familiar with, small pumpers are protected. That's the goal in these cases, is to protect everybody. And in each of these cases, the ultimate goal is to effectuate a means that people can continue to produce water, but make sure it's a coordinated effort that works for everybody. So with that, the district elected to proceed with the comprehensive adjudication. A mailer will be going out hopefully next week that'll provide notice of the comprehensive adjudication. The reason I say hopefully is that through all the supply chain issues that you've probably heard about in the news, we learned that there was a paper shortage that slowed us down a little bit. But with that, you should be receiving a mailer sometime the next week or two. That particular document will provide much more detailed information as to what you can and should do to protect any water rights or claims that you may have. We will be posting regularly information on the district's website under an FAQ section that will provide information regarding the adjudication, important dates, and whatnot. The only pending court date, at least as it relates to the adjudication, is March 15th. And again, that information will be provided for in the notice, and that's just a status conference with the judge. No substantive determinations will be made on that date. Nothing will happen on that particular point in time to negatively or affirmatively impact anyone. Just be reporting back to the court. Ultimately, at the end of the day, what the goal again here is to craft a physical solution. What normally happens, and again, every case is different, but the players will sit down and try to negotiate a settlement that works for everybody. And that's what happened in the Antelope Valley. There were a few holdouts, but for the most part, agricultural interests, both large and small, industrial interests, the municipalities, water districts, etc., got together and worked out a solution that worked for everybody. Under the applicable statutes, we can try to negotiate a settlement, and once a certain percentage of the pumpers are in agreement, we can present that to the court for approval, and that's obviously the goal here. Obviously, the goal will be to have 100% support for anything we present to the court. That's the goal, not always what occurs. But again, it's intended to be a cooperative process, not an adversarial one, even though we are, in fact, in court. And again, being that we have the GSP, we'll have to coordinate with that effort, including involvement of the Department of Water Resources, who will be involved in what we do and what ultimately comes out of the court process. Maybe a last add on the physical solution is I've said this several times, but what it does do is provide certainty, which is perceived to be a good thing. It'll provide some long-term solutions and address long-term water shortages in the valley. The physical solution will be ultimately overseen by the court and a judge. So once a judgment is in place, parties can go back to the court over time and seek changes to the physical solution. In most of the cases that I've seen, there have been quantified water rights, but also quantified safe yield. But that can change over time. Either it can go up or down depending upon environmental conditions, and there will be a process in place to adjust that as well. So that's what we're doing, and I think that's all I have to say. Oh, I think I mentioned that the mailers are going out next week again. And again, if take a look at those, there'll be a lot of detailed information as to what's happening and when and exactly what we're trying to do. And if you have any further questions, once you receive the mailer, obviously we're here to answer questions this evening, but once you look at the mailer, there'll be information there to direct you on how you can get more information as well.
Thank you, Doug and Jim. And so at this point, we'll entertain any questions or comments from the floor. If you'd step up to the microphone and please state your name.
Good evening. I'm Don Decker, member of the GA TAC representing the domestic well owner community. Mr. Everts, I did ask you this question once before at a water district meeting, and it is that all of the major pumpers have their positions presented to the court by their attorney that's long since been in place. The domestic well owner community does not have a combined community representative that we have actually established. And my question is the court itself, in a sense, providing that representation, or this is a legal question, not so much a physical question, I think. Who is representing the domestic well owners before the court?
That's a very fair question. We did talk about that at the
Yes.
last water district meeting. The answer to the part of that question is no, the court will not be representing or advocating a position on behalf of any party. The court's a neutral arbitrator, judge, whatnot. There are several different mechanisms that can be employed to retain counsel so that each individual well owner isn't having to hire an attorney, because that obviously could be cost prohibitive. I understand that. There are several different means that can be pursued. I think you have my telephone number, so I have some ideas in that regard. I obviously want to talk to the board about my theories before I vet them publicly, but there are some ways that can be accomplished, and I think that's we've got some things we can do.
All right. Thank you again. Your explanation this evening, and I think from Mr. Zadiba and Mr. Worth, were clear and to the point, and I think I can speak for this audience that it was a time worth spent by all of you. Thank you.
Thank you. And if I could just maybe add one more thing, is that many times in lawsuits, as I mentioned before, it's lawsuits by their nature tend to be adversarial, and that's not the goal here. And if time needs to be taken so that parties are properly represented, we'll make sure that happens.
Yeah, thank you. In this particular situation, though, we are so far out of balance that the knives have long since been sharpened up.
I understand.
Josh Nugent from Mojave Pistachios. Appreciate you guys being here tonight, and appreciate you guys being here tonight as well. So I just want to start off with a general note of support to the Water District, and that we really appreciate tonight's format and the board members especially taking the time out to be here. Our hope is ultimately that we can no offense to all the lawyers in the room, that we can ultimately bypass some of this legal complexity and cost of any court actions through discussions and collaboration. The DWR has offered support through facilitation. I've heard that the Water District's shown some positive desires there, and so we're very excited and pleased to hear that. We hope the facilitation process can achieve many of the goals of the adjudication, including getting everyone involved with much less heartburn for the whole valley. So we wholeheartedly support the spirit of your presentation tonight, and we hope to find ways to work with the Water District as a partner. So thank you.
My name is Ralph Lockenmeyer. I'm just a resident of the city, but I'm trying to understand this a little better. You didn't mention much of the role of DWR. Are they going to be represented with a lawyer in this thing, in this court case, to see that, give their version of how the law should be followed? Or where do they fit into this?
In terms of the adjudication, DWR will not be a party to that. They're not a pumper or a landowner within the basin. In terms of an adjudication, if there were a final judgment out of the adjudication, it would need to be submitted to DWR to make sure it was close as I could say SGMA compliant. The groundwater sustainability plan and or the adjudication, who they're going to be married in some manner, they both have to achieve sustainability. And DWR will look at the judgment and look at what the court's order is and make a determination, much like they're, I assume, making on a GSP, whether or not that order results in a sustainable plan for that basin. So DWR's involvement would be more of review and approval.
So they could throw out the whole court case, say it doesn't meet SGMA, and we'll start over.
I'm not sure that's how it would happen, and it needs to be understood. I should say this is that this is the comprehensive adjudication that's being filed in this basin, along with an approved GSP. There's only been a couple that have been going on in the state so far. It's still very early in the process. There's some statutes you read, so everybody's making assumptions. I'm not 100% sure what DWR would do or what the court would do. I don't think DWR can invalidate the court ruling because we're reading statutes and there's no real prior precedent for us to base it off of. So perhaps comment to the judge, Doug?
I think Jim's absolutely right. Obviously, whatever comes out of the adjudication, we're not going to do in a vacuum. So DWR will be well aware of what we're doing along the way, and the goal obviously will be, obviously the court has its own jurisdiction, but to have something that DWR will be very satisfied with.
I guess I was having the same question about SGMA. It sounds like it's thrown out at this point, and the judge is going to decide what's happening. Now, I think I just heard that the Groundwater Authority plan, that if DWR supports that, the Groundwater Authority, the local Groundwater Authority, then they'll still have some input. But one of the questions I had was, if I went out here in the desert and bought 5 acres, wanted to put a house on it in 10 years, there's under the Groundwater Authority plan, I've been told, nope, nobody can drill any more wells. Is that Groundwater Authority statement still applicable?
I don't want to go too far into the GSP or the GA. This is a water district board meeting. I think what would happen, it's a hypothetical. I think if you were to do something in 5 or 10 years, there'll be a process in place where you would go to the GA and they would set forth the rules and conditions under which you could drill a new well. I haven't heard any discussion at any meeting where somebody's discussing a well moratorium within the basin.
I've sure heard it.
Fair enough.
Okay, thank you.
Nick Panzer, Ridgecrest resident. I'd like to build a little bit on Mr. Lackenmeyer's question concerning the role of the Department of Water Resources. I'm of the impression, and I think it's section 10.737 and following of SGMA, that DWR will conduct a similar review procedure that they are going through right now with respect to the adjudication that comes out of the court ruling. You have said, if I understood your answer to Mr. Lackenmeyer's question, the DWR would not be directly involved in preparing the case for the cross complaint before the court. And so that would suggest to me, if that's true, that it would be the water district that would be defining undesirable results, which drive sustainability according to SGMA. And that's section 10.720.1b says that, in effect, avoiding undesirable results takes precedence over water rights. So my question is it the water district that's going to come up with those definitions that DWR is demanding, in effect, from those basins it's already told you have not properly interpreted and applied SGMA in defining undesirable results? Is that what the water district is now prepared to do that themselves, incorporate that into your cross complaint so that DWR will have something that can approve or disapprove for lack of inadequacy? Thank you.
Fair question, and maybe part of the way to answer that is that what comes out of the comprehensive adjudication process won't be what I would put as the water district's plan. It will be hopefully a settlement by the majority, if not all of the parties. That includes all the interests, the water district, the ag interests, everyone else, the Navy, federal government. So it's again, it's not a water district plan per se. What ultimately will come out of this is not a water district plan. Yes, it's the water district's cross complaint, so maybe I'd just like to clarify that. DWR will ultimately need to review it and bless it. You raised some interesting questions about the marriage between DWR and what comes out of the court process. This is admittedly somewhat a new procedural process, having the comprehensive adjudication with the pending GSP. But again, the court will be considering the GSP, whatever DWR approves or doesn't approve. The court will obviously take a look at that. I'm not sure if I'm directly answering your question or not, but it's a process where what comes out of the adjudication will be presented to DWR and hopefully secure DWR's blessing.
One other thing, I think that what was it? I'm trying to say that. Totally, go ahead. I'll get my thought right back.
I'm struggling to find my tongue also. I'd like to build on Mr. Decker's comment about the sharp knives. I understood your reply to my question. It will be presumably a collaborative effort. We've tried that for the last 5 years. The knives have been sharpened. They're extra sharp now, and they're just waiting for this process. It's still the same question, observation, comment, if you will, that I have. Someone has to come up with those undesirable results, because DWR seems deadly serious about that. They're not going to let you project out and find out where you're going to be 20 years from now and set a minimum threshold based on that number. They want to know right now something that they can follow and monitor, and that's what they're telling these basins that are on track to have their plans disapproved. You've misinterpreted and misapplied the definition of undesirable results. So whether it's the water district or everyone collaboratively, it's got to be done. And it's going to be a very interesting process with sharp knives out.
And whatever comes out of this process has to be fully supported by the science, which will be presented both to DWR and the court ultimately.
And we got to prove it to the judge, too, right? Huh? We have to prove it to the judge,
yes,
like DWR.
Wes Katzenstein, domestic well owner, and also a member of the Policy Advisory Committee. And I've been wrestling with this. It seems to me, I guess my first question would be, has the world of adjudications changed? There are guidelines that now exist in SGMA. For example, Groundwater Authority, as I recall, cannot take away water rights, but it can charge fees. And so I think the approach that the Groundwater Authority has taken has been, in my mind, these are my words, to prioritize water rights and say that any water rights below the cutoff of the recharge, you still have your rights, but you have to pay fees. So in my mind, it comes down to a prioritization of water rights, and the water district kind of got half the baby's sawed in half and half isn't, or something. And as Mr. Panzer pointed out, that there are a number of new SGMA rules, and I guess my first question would be, does an adjudication have to respect the new rules that SGMA put in place, like undesirable results, like you cannot do away with water rights, but you can charge fees? Will these kinds of things occur, or is it kind of the good old days, but is an adjudication clunking heads with SGMA, or does it ultimately have to satisfy SGMA? I guess that would be my first question.
You're all asking very good questions. There will necessarily be some clunking of heads in the legal terminology. But I'm drawing a blank right now because I was going to respond to your first part of your question there.
The physical solution, as I understood your question, it cannot just ignore the requirements of SGMA. In fact, Water Code Section 107.37.2, I don't want to read the whole thing, says that in an adjudication action for a basin required to have a groundwater sustainability plan, the court shall manage the proceedings in a manner that minimizes interference and is consistent with the attainment of sustainable groundwater management within the timeframes established by this part. So when we were talking about undesirable results and DWR looking for a definition, maybe you get the definition right or wrong, but in the comprehensive adjudication, if we go down that road, I think in a perfect world, it would be a collaborative effort, and it wouldn't just be an effort by the parties. There would have to be something presented to the court. So the judge also believed that we had met the criteria of sustainability, whatever else was required under SGMA, and then it would go to DWR after the judge thought it was a sufficient judgment.
And I apologize for the brain fade, but I got my thought back. You mentioned the term priority. And how the GSP is, quote-unquote, prioritizing water rights.
Those are my words, yes.
I know they're your words, and they're also the words that are at issue in the two lawsuits filed by Searles Valley and Mojave Pistachios against the Groundwater Authority. It's their contentions. I'm not taking a position on that, but it's their contentions that the GSP improperly determines water rights. What I can say is through the process of the adjudication, we can do that.
The only way in my mind I could see the Groundwater Authority or SGMA's approach lining up with an adjudication would be that maybe the adjudication redefines the priority of water rights, and then the Groundwater Authority implements fees beyond
the 7650 cutoff, just like they're doing, maybe on a different prioritized list of water rights. That's just my thought on that. One last question. I think that adjudications I've heard have a history of taking a long time, going on forever. Then I've heard it said that there's a new state law that says that can't be, that they now have to happen more quickly. Do you guys see that this adjudication will happen rather rapidly, or will it be 10 years from now and, we've drawn her down a much more as far as the groundwater level goes?
That's a very good question, and I will give you my best answer. The Antelope Valley case took a long time. And part of the reason that case, but that's going to be different from what I think is going to happen here. Okay. The reason that the Antelope Valley, or at least a significant reason or portion of the case took so long, is that in that particular case, the federal government needed to be involved because of Edwards Air Force Base and Plant 42. But at the time that lawsuit was filed, there was not a process in place, the Comprehensive Adjudication Act, that allowed notice to go out to all landowners like we're doing here. So what happened, and I'm sorry if I'm getting a little wonky, but what happened in the Antelope Valley case is that to bring in all property owners, rather than giving mail notice to everybody, classes were formed. There was a class, like a class action lawsuit. There was a class of small pumpers. There was a class of non-pumpers. And just getting that process in place took several years, if not longer. So I think that case, even the end result of it was very positive. It took an exorbitant amount of time. Mojave, on the other hand, that moved through the court process pretty quickly. What happened there was that a group of engineers and attorneys and stakeholders got together very soon after the lawsuit was filed and met literally weekly to try to come up with a sophistical solution to present to the court. And that's what happened after just a few, it's still a long time, but just a couple of years, that action was resolved through the trial court. There have been cases more recently where all the parties got together right out of the blocks and came up with a fiscal solution presented to the court, and they were done. So my goal, I can't make any promises, but my goal would be to see a working cooperative group here try to come up with some kind of solution that we can present to the court and have approved in short order.
Well, I hope you're successful. Not only are the knives sharp, they're going to have to cut an awful lot of meat off the bones. So thank you, guys.
Understood.
Hi, I'm John Gorman, a city resident and a small pumper, as you guys say, de minimis. When all this first started, us small pumpers were thrown a sop by Sigma that said, if all you're pumping is less than 2 acre-feet per year, you're sort of off to the side on all this. God bless you. And I was warmed by that. When the comprehensive adjudication first came up, I was also warned that you small pumping rascals, if you get involved in this, you're going to lose that lee shore you've been happily wading in, and the business of only pumping less than 2 acre-feet per year isn't going to help you at all. You'll be in the fray with all these sharp knives right along with everybody else, and we're the group that's not represented by legal counsel here. Is all that true? That's my simple question. Is it true that 2 acre-feet, less than 2 acre-feet per year pumping has the same result after comprehensive adjudication as it does now? That's my question. Neither one of you want to answer it.
Well, I don't know what the final judgment looks like, and there's probably various ways that de minimis pumpers could end up. They could end up in a position similar to where they are today. They could come up in a position differently. A lot of different factors come in. It's early in the process, so I wouldn't want to speculate, but I would certainly allow Doug to if he wants to.
Thanks. What I can say is that in all the cases that I've either been involved with or am familiar with, there was a sincere and effective effort to protect and preserve small pumpers. How that ultimately rolls out here, I don't know. What happened I'll just give you another example. In the Antelope Valley case, I believe it was pumpers that produced more than 3 acre-feet per year were effectively left alone, with the exception of they have to pay an administrative assessment, which just helps fund the water master. What that fee is, I don't know, but I don't believe it's exorbitant by any means. But the goal there is to protect the pumpers. Mojave, there was a larger per acre foot exclusion. There have been other cases where they were filed against all pumpers, and ultimately de minimis pumpers were dismissed because they could come up with a physical solution that resolved issues without the small pumpers. I don't know if that's going to happen here or not, but my point being is that small pumpers will be in the forefront of our thoughts and what we try to address.
I thank you for that. And by the way, while I'm thanking, I want to thank the Water District for making this happen. This is great. I'm learning a lot sitting back there. One last question. Our plan has not been approved yet. Is there a time limit? Or can someone sit on it indefinitely? And in doing so, would that stall comprehensive adjudication?
No. There is a timeline. DWR's review ends at the end of this month, so there should be a decision from DWR on the groundwater sustainability plan. I'm sorry, by the end of January. End of January, I apologize. January of 2022. So I don't think they're sitting on it. There's a deadline that their DWR is going to abide by. I believe there's only 8 basins left that they haven't provided some type of comment on. So I'd be surprised if they didn't have a timely comment on the GSP. As we sit here today, DWR's decision on whether the GSP is compliant or not, in my opinion, as I sit here today, doesn't change the fact of the adjudication.
My friends, thank you.
Judy Decker, de minimis well owner, along with my husband, member of the PAC for the Eastern Kern County Resource Conservation District. I have a couple of questions. Both of you have mentioned several times a physical solution. Now, there are many physical solutions that are available. Well, I shouldn't say many. There are quite a few physical solutions. Does an adjudication settle on one?
The answer is no. And what a physical solution really is intended to do is be tailor-made for a particular area.
Understood.
So if there's a physical solution from another basin that we can take some of what they've done and plagiarize off of that, sure. But we need to obviously, from a legal standpoint, we can come up with legal mechanisms that work, but obviously the science has to work with what we're doing legally. I'm not sure if I'm answering your question or not, but we can learn from what's been done elsewhere.
Well, okay. You've noted both Mojave River adjudication and the Antelope Valley adjudication, and both of those areas conveniently have state water project canals going through them. The only aqueduct we have going through this valley belongs to the Department of Water and Power, and that's a different situation. And the other question I have is, when an adjudication is done, is there a time limit on it? Can it be changed, amended?
The time limit is how quickly we will get it through the court system initially. Most judges just want to move things along as quickly as they possibly can. But maybe the better part is to answer the second half of your question. And I'm almost most certainly there will be processes in place to make adjustments as things move along, because we'll do our best between the stakeholders, the scientists, the engineers, the lawyers to come up with the best physical solution. There'll be information we'll develop in the future, weather may change, whatever.
That's what I wanted to know. Is if, for instance, one of the things the Water District is eagerly looking at is the use of recycled water. Well, let's talk theoretically, if the Indian Wells Valley were to grow, and even if they use the recycled water as is, it's some 2,000 acre feet at present, it may not be enough for us to reach sustainability by just using that. So we would have to do other things. Or if we grew, we would have to do other things. And as time goes on, while people like to think they can predict the weather, they're sometimes not too good at it. And as you know, we get the leftovers here, not only in rain on the valley floor, but in recharge in our mountains. So that is probably going to continue unless something drastic happens, and that needs to be taken into account for the future. Thank you.
Yes, go ahead.
This is a follow-up to my earlier question and your response. As I understand it, Department of Water Resources won't directly be involved in developing whatever is presented to the court, nor will the Water District alone be responsible for that, but rather it will be this collaborative effort. And so my question would be, what happens if that collaboration collapses? What process takes over to get something before a judge that can be ruled on if, in fact, when the knives do come out and the meat is all cut off and we're now lying on the ground, what will happen at that point? How does that process proceed if, in fact, we can't find the collaboration that we've apparently been unable to achieve ourselves in the last 5 years? What will replace that?
What's the saying is, if you're a fighter, you make your plans until the first punch is thrown. What you're saying is if the collaboration effort falls apart. And things like that can happen. What the adjudication statute actually provides for is that if necessary, we can have certain phases of trials to have certain issues resolved by a judge. And for example, in the Antelope Valley, and I know I keep coming back to that, one of the sticking points in that particular case was what is the safe yield of the basin. There were very different views in that regard. So we actually had a phase of trial in that particular case where the court heard evidence from expert witnesses on the safe yield of the basin, and the court actually made a determination in that regard. And once that determination was made, that opened the door for further discussions that ultimately led to the negotiated settlement.
Could I get Mr. Worth to read again that sentence that said the solution has to be consistent with avoiding undesirable consequences?
I tried to paraphrase, so I'll just go ahead and read the statute for you so you can read the whole thing. This is Water Code Section 107.37.2, and it speaks to situations where an adjudication has been filed in a basin where there has a GSP is required. And it says, in an adjudication action for a basin required to have a groundwater sustainability plan under this part, The court shall manage the proceedings in a manner that minimizes interference with the timely completion and implementation of a GSP, avoids redundancy and unnecessary costs in the development of technical information and a physical solution, and is consistent with the attainment of sustainable groundwater management within the timeframes established by this part. So when you guys are asking this question, what's going to happen, this is what we're trying to interpret from.
So it doesn't say consistent with the avoidance of undesirable consequences.
That does, I read something else about that, but I'm not sure where.
I thought I heard you read something like that.
I've read more than a couple things. I apologize. Well, I think what this does say, though, is that the physical solution has to be consistent with SGMA, the standards by SGMA. I think they're both going to be judged by very close standards.
So you're saying they're going to have to avoid the undesirable consequences? I'm getting confused.
Yes, I believe that's correct. I believe both the GSP needs to avoid undesirable effects, and I think any final judgment from an adjudication would have to do the same thing. Would you agree with that, Doug? Okay.
That's the part that worries me, is that nobody's in there defending the the avoidance of undesirable consequences, and that with lacking that the judgment's going to come out that squeezes away from that. Everybody here, or everybody that's involved, wants all the water they can get, and I'm afraid we're going to come up with a judge's decision that doesn't avoid the undesirable consequences. I just want to lay that out.
Sure, but be aware that we're going to have to present evidence and convince the judge that this plan does not create undesirable results. So this isn't a situation where the parties are just going to give a stipulated judgment to an uninformed judge with no further argument. That's not it. The case will have to be, just like the GSP has to make its case that that there's no undesirable results. I believe that the adjudication judgment, stipulated physical judgment, would have to do the same thing.
Ralph, I think I can answer your question. What you did read, Mr. Worth, was accurate. It said that we have to result in the sustainable management of groundwater, and that is defined in Section 71020V as the avoidance of undesirable results. So, Ralph, that's the connection you want and you're looking for. They are definitely connected. Yeah. Okay.
Yeah, my next concern is, of course, who's going to make sure that this decision avoids those.
Okay, are there any more comments from those that are in the chambers? I see we have some, looks like we have some callers, and I appreciate their patience. Can we go ahead and put one through? Oh, wait, do we have one more? Hold on. Caller, hold on.
Scott Heyman from City of Ridgecrest, City Council and Chairman of the GA Board. I have a question pertaining to a couple topics that were brought up a little earlier. One in regards to the length of time that the adjudication process is going to possibly last. Your comment was that it could be as little as a couple years or a few years up to the long end of, the 17, 18 years or however long it was in some of these other adjudications. But is the water district prepared, the cost, the yearly cost that it's going to be putting out for this adjudication? And with that, have you come up with the cost that's going to be incurred onto the ratepayers and citizens of Ridgecrest? Do we have a forecast on that? And secondly, my second question pertains to the de minimis users. So I'd had a conversation with one of the directors on the water district, and the conversation went into the de minimis users and the fact that, so I asked the director, one of the board members of the district, I asked him, I said, so if I get this right, a de minimis user has 2 acre-feet of water. If they're only using 1 acre-foot of water, is the water district wanting that other acre-foot of water? So my question to you is that something that the district is looking at in the adjudication process? So those are my 2 questions.
Well, as we sit here today, I believe that the water district has considered the cost, and right now is intent to continue to go on. We can estimate costs. The actual costs going forward on the lawsuit can depend on a lot of different things. For example, if there's true cooperation amongst the stakeholders, it can go a lot quicker and it won't cost as much money. If everybody continues to disagree and fight, then those costs are going to increase. I don't know exactly how much. I don't think there's been a good estimate on water-related matters in a while, but we try to continue to keep the water district apprised of the costs. They're aware of them. They think that while they may be high, this is very important, and it's something that needs to be done. With respect to whether or not the water district is attempting to take any water from the de minimis, no, that's not the plan. The plan is to try to come up with a physical solution to help bring sustainability to the basin. What the specifics are and how it's going to pertain to each pumper, way too early to speculate. Too many variables out there, and I wouldn't do that.
Thank you very much. And so back to the cost factor to the ratepayers, so is there going to be any forecast as to what this is going to end up costing the ratepayers?
I would assume that we will continue to update the board on an annual basis. I'm not going to make an estimate and says it's going to cost you $5 million over 10 years because that would really, quite frankly, be a guess. Too many variables, too many factors go into it. So we gave them an estimate for the first year, and we will continue to do that. We'll evaluate where the lawsuit stands and the evaluations, and we can be able to give a better estimate from a shorter time frame, depending upon what the board requests.
Good enough. Thank you.
Okay, I see we have a caller, and I appreciate your patience. Would you identify yourself and go ahead, please?
Yes, this is Renee West of Lusk. Can you hear me?
Yes, go ahead, please.
Okay, I have a whole bunch of questions because I am not literate when it comes to legal documents. I went to the Indian Wells Valley Water District website and saw all these documents that list defendant, cross-complainant, plaintiffs, and there's a whole list of cross-complainants, one of which I'm familiar with. And I am totally confused, and I'm sure a whole bunch of people out there are like me, don't know anything about what this is going to mean to them. I'm an individual homeowner that lives on a property with no well. I get all my water from the water district. I live in a homeowners association, and unfortunately, I read that their name is listed on this, I guess, cross-complainant list. They're in 2 places, one on the page, the 3 I's page, I guess it's page 3. They're listed as number 7, and then again they're listed as number 24. I am totally lost about what is this going to cost me? How much is my water bill going to go up? You know, you had mentioned that the water board was given an estimate of the first year of cost. What is the first year of cost to the average water district customer that just the lawsuit's going to add on to their water bill? I want to know if what I have to do. You say that we're going to get some flyer. I don't own a well, but the homeowners association owns a well. So am I still going to get the flyer, and do I have to go and get a lawyer? And does my homeowners association have to get a lawyer? And what is going to happen to the real estate sales that we have this adjudication? Do you have to disclose this when you're selling your property? Well, you know, the water district's in adjudication, you know, and your water bill might go up. Do I have to disclose that if selling a property? And then what am I required to do by law because of this adjudication? Because you said everybody has to participate that's a landowner, okay? And won't the water district have to pay out millions of dollars over the years? And then you're saying you don't know how many years this is going to last. Well, how long did the Antelope Valley lawsuit last, and how many millions did they have to pay? Can you divulge that? Those are my questions.
This is Doug Everts. There were quite a few questions there. Maybe I'll start with the mailer that will be coming out to all property owners and well owners. That will also contain a cover letter that will, I think, answer a number of your questions. There's also an email address on there that you can use to request any further information that you're looking for. In addition, we'll be updating the Water District's FAQ website for more information. I think I can say, though, that, and I'll look to Jim and Don on this one, though, that Water District customers will not be impacted by the adjudication. I think we have that up on the FAQ. So if you receive water from the Water District, you'll continue to do so.
There will be some financial impact. There are legal costs that are passed on to the Water District ratepayers for the adjudication. But if you are just a district customer, you do not have a well, you should not be impacted by the adjudication. No need to assert any rights because the Water District is protecting their pumping.
What about the homeowners association that I live in? They have a private well.
I would anticipate if there's a homeowners association board, they should take a look at the mailer or the information that they receive, and if they have any questions, follow up.
Are they going to have to get an attorney?
That's a decision they'll need to make. I don't know the specific